Oyez, oyez. All person having business before the Honorable Court of Appeals of the New York State are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, everybody. Please be seated. The first case on our calendar this afternoon is T.H., an adolescent offender, against the people of the state of New York. May I hear the attorneys' names for the record? For the petitioner. Yes? Good afternoon, Ms. Donahue.
Jessica Insalaco for the Respondent,
Good afternoon, Ms. Insalaco. Does the petitioner have any applications before we begin? Very good. Would the petitioner please proceed?
Good afternoon, Your Honors, and may it please the Court. My name is Elizabeth Donahue, counsel for Petitioner, T.H. At this time, Petitioner respectfully requests to reserve 1 minute for rebuttal.
That will be granted.
Would this Court like a brief recitation of the facts?
Yes, very brief, please.
This case is about a redeemable youth who fits the exact criteria for what the Raise the Age legislation was intended for. T.H. is a 17-year-old adolescent.
Ms. Donahue, your client, T.H., is 17 years old, but the lower court deemed him incorrigible. What should we do with a person like this? The statute raised the age of criminal responsibility, but there are exceptions under exceptional circumstances. Why is your client not in that exceptional circumstance sphere?
Yes, Your Honor, it is our position that the people have failed to meet their burden of proving that very high extraordinary circumstances exist.
Can you tell me and us what the burden is?
The burden is by a preponderance of the evidence, Your Honor. And in this case, we have a redeemable youth who has showed that he can rehabilitate in family court. Based on the totality of the circumstances, this case should be transferred to family court for 3 reasons. First, T.H. is amenable and would benefit from the heightened services provided in family court because T.H. is redeemable, and family court is a more appropriate form of adjudication.
May I respectfully ask, though, if preponderance of the evidence is the mere standard, it doesn't take much, does it, to satisfy that?
Yes.
It's simply more likely than not, more than not, better than equipoise.
Yes, Your Honor, but the court in People v. D.B. stated that the people would face a very high burden when opposing the removal of the case to transfer to family court. And in this case, we have several mitigating factors to look at pursuant to T.H. in particular. For the second reason, the people have failed to meet their very high burden of proving that extraordinary circumstances exist because the legislature intended that denials of the case to transfer to family court be
Let me understand again, Ms. Donahue. I hate to keep interrupting you. If you say the high burden is merely preponderance of the evidence, it doesn't take much, right?
It is our position that, based on the case law, the legislative intent is very clear, that the people would face a very high burden, and that removal and that retaining the case in youth part would be a very rare occurrence. Additionally—
Speak to that rare occurrence. What specific factors would reach that rare occurrence?
Yes, Your Honor. The court in People v. TP stated that only 1 in 1,000 cases would be kept in the criminal court.
Is this that one?
No, Your Honor. Respectfully, no. It is our position that it is not the 1 in 1,000.
But TP was a trial court case. We only have 1 appellate division case so far. It's a 4th Department case. And so should we in this court, the highest court in the state, be guided by that when we decide questions of law? And as a matter of law, the issue presented for us is which court is the most appropriate court, not which court is the best court in the interest of justice for this child under the statute.
Yes, Your Honor. However, it is our position that the people have failed to meet the very high burden of proving that extraordinary circumstances exist. And in the court in People v. Guerrero stated that all cases outside of the most serious felonious conduct are presumptively transferred. And
aren't you referring to a high standard of proof? Isn't that what Guerrero says, not a high burden of proof? And as my colleague raises, the burden here is merely preponderance. So when you say a high burden, I think the quote that I recall from Guerrero is a high standard for the DA to meet. Would you agree with that?
Yes, Your Honor, we would agree with that. And it is our position that they do not meet this high standard that the legislature has intended for the people to have.
So to answer Justice Glover's question, what would the factors be that would warrant retention in the youth part?
Yes, Your Honor. The court in People v. DJ provided a list of several mitigating factors that the court should consider and several aggregating factors that the court should consider. And in this case, we have a youth who who has multiple mitigating factors present. And some of the petitioner concedes that there are some aggravating factors present here. However, the court should look at the totality of the circumstances in relation to this specific youth and to this individual youth's circumstances.
We look at the totality of circumstances, and we all agree that would be the reviewing method. We see a youth who appears to not be willing to abide by the rules. He may be very bright, he may be doing very well in school, but also, I hope his parents are here today, his parents don't seem to be willing to, how we say, participate in maintaining his appropriate discipline. He's engaged, by my count, by close to 10 antisocial acts, some of which are actually dangerous and potentially violent. Among them is, of course, driving the principal's car after stealing it through a crowd of people. I mean, what else do we need to have other than somebody getting seriously hurt or killed before we reach the point where punitive sanctions are appropriate rather than remedial, which is family court versus criminal court?
Your Honor, in this instance, family court is the more appropriate adjudication for this matter, considering that we have a first-time offender. TH has never been before the court before. This goes to show that he has never had any chances to show that he is irredeemable. Additionally, it is multiple offenses that show irredeemability. And in the court of People v. DJ, that court gave that adolescent offender 4 prior chances to transfer the case to family court before they deemed him irredeemable. Additionally, the services that
Does the person have to have multiple contacts with the criminal court justice system before we begin to acknowledge that there's a problem here? I read the facts here that there are more than the 10 that he put together in a row. Prior to that, he was engaged in conduct. And I'm just wondering, just because he didn't have prior contacts, how we're not to take that into consideration too. And his family doesn't seem to be assisting in this process.
Yes, Your Honor. However, the parents are now involved due to the fact that TH is facing a potential criminal record in the youth part that will follow the 17-year-old child in the eyes of the law for the rest of his life. He has dreams of going to college. He has not shown the court in any way that
he's dreaming of being, having 1 million+ followers is what I see him dreaming. I don't see the dream for college.
Yes, Your Honor, the followers were the driver of this conduct in the first place. However, he has shown that he does want to go to college and that he has expressed that. Additionally, his parents are now supportive due to the fact that he's facing a criminal record in the youth part, which could prevent him from going to college, prevent him from getting a potential job, from being able to vote, considering that this is a first-time offender and that the services provided in the family court will be much more suited to this situation. They could mandate a court order, which will have him be deterred in the sense that he could be doing mandated counseling or community service.
Do you think that order, in light of the history of this case and the family's lack of involvement, would somehow ensure that the rehabilitative processes in the family court would assist your client in making the correct decisions in the future?
Yes, Your Honor, that is precisely what Petitioner is arguing. He will be in front of a family court judge regularly. He will be monitored. And although there is a slight risk of transferring this case to family court, it is a necessary risk and one that the legislature specifically intended for the court to take. The court in People v. DJ stated that it was the intention of the Raise the Age legislature in the first place for youths that have been charged with crimes to be rehabilitated rather than incarcerated. And the services that will be provided in family court are much more appropriately suited to the situation. Considering that the family is now involved, he has the foundation to be able to rehabilitate, be deterred, and come out into society a better person. Additionally,
So what you're saying, most respectfully, is we got to give him one last chance. Isn't that the bottom line on all this?
correct, Your Honor.
Why? Why should we give him one last chance as a matter of law? Because again, the Court of Appeals is not a court of justice. That was the appellate division. They said, Justice, you stay in criminal court.
Yes, Your Honor, because based on the mitigating circumstances of this particular youth and what the legislature's intent...
To the mitigating circumstances?
Yes, Your Honor. One of the mitigating circumstances is that he is a first-time offender. Another mitigating circumstances is his age. The fact that he is 17, he does not have the same insight and same ability to understand the ramifications of his actions as a 25-year-old would. And in this day and age, social media and being trendy is held in very high regard, unfortunately, but that's just the way that it is.
But Judge Glover has a good point. Is he interested in being in college, if that's important, or is he interested in having 1 million followers?
Yes, Your Honor. The 1 million followers was the driver of the 10 days to go viral challenge in the first place. However, he does have aspirations to go to college. As Your Honor mentioned, he does have a 4.0 GPA. This shows his ability to work towards a goal, to be attentive, and it shows that he can be deterred by the conduct and be able to rehabilitate in family court. Additionally, another mitigating factor present is the fact that his parents are now also involved, and they are willing to put in the work, considering that he is facing a criminal record in the youth.
Any record-based support for that statement? Or you're just most respectfully saying it? Have we seen anything in the record of this case, that the parents are now involved?
Yes, Your Honor. In the record, it states that now that TH has been charged with crimes, the parents are now...
Because they're worried about him going to college.
Correct, Your Honor.
Okay, very
Correct,
good.
Your Honor. Additionally...
Donahue, can you address, we're here, I think, the standard, the proof standard is extraordinary circumstances. And I haven't heard you argue extraordinary circumstances. You've gone into social factors of your client, et cetera. Talk to me about the acts, the ones he was charged with, and the ones he was not charged with that are in the record, and how you're arguing that they're not extraordinary circumstances under the Guerrero and under the law. But tell me why they are not.
Yes, Your Honor. It is petitioner's position that TH does not satisfy one of the aggravating factors present, which is acting in an especially cruel and heinous manner, due to the fact that heinous is defined as acting hatefully towards someone. And in this case, there's no evidence in the record that he was acting particularly hateful towards anyone, or that he intended for anyone to be physically injured, or that he wanted to harm anyone. Although petitioner concedes that people had emotional harm in this instance, there's no evidence in the record that he intended to inflict any physical harm or act hatefully towards anyone. And due to this, it is our position that it does not rise to the level of extraordinary circumstances when taking into account the totality, including the mitigating circumstances of this youth and the legislative intent, which is clear. The court in People v. TP stated that it is the court's primary consideration to ascertain and to give effect to the intention of the legislature.
What do you think about his conduct and the foreseeability that it could have caused that harm? The bomb scare and the like. What do you think about the foreseeability factor?
I'm sorry, can you...
Sure. I mean, when we have his actions and we have extraordinary circumstances, when do you think that we should consider that there's the potential that this harm would be yielded by the conduct? Because you're going with state of mind, intent, desire, or purpose, but what about the foreseeability factor?
Yes, Your Honor. Petitioner understands that that there was a sense of luck in this case. However, the court still has to look at the mitigating circumstances present of this youth and the fact that he is a first-time offender. And due to the fact that he has never engaged in any criminal actions prior to this instance, although he has engaged in conduct before this, they were not criminal. And due to that, it is our position that he does not rise to the level of extraordinary circumstances that it is on the burden of the people to meet. Additionally, the court, People v. TP, stated that the court's primary consideration is to ascertain and give effect to the intention of the legislature. And in this case, the legislature is clear that they intended that adolescents who have been charged with crimes to be rehabilitated rather than incarcerated. And that this court, Your Honors, I see that my time is up. May I briefly conclude?
Yes, please. Thank you.
Keeping this case in the youth part would cut against the direct intention of the legislature, and in this case, the people have failed to meet their very high burden of proving that extraordinary circumstances exist. Thank you, Your Honors.
Thank you very much, Ms. Donahue.
Thank you.
Ms. Insalaco, for the people, and appellate.
Good afternoon, Your Honors, and may it please the court. Jessica Insalaco for the Respondent, the people of New York. The court should affirm the appellate court's decision because this case is anything but
The
normal.
appellate court, Ms. Insalaco, basically said, let's send a message. Are the courts in the messaging business? Is that the point here?
Your Honor, the people don't believe that we're in the messaging business. We're looking at a case-by-case basis and looking at this case in which this adolescent offender premeditated, planned, and executed a days-long crime spree that terrorized the community.
Crimes that were charged, I don't mean to belittle them because they are serious
Yes.
enough, but they're all nonviolent felonies. And in so many words, nothing serious actually occurred. Maybe there was harm, as conceded by your colleague, in terms of fear and all of that, but your client, the people's claim is perhaps, is it not overshadowed by the notion that this is a young man, he has a need to obtain rehabilitative services, and putting him in a punitive courtroom is not exactly the best place for him as a first-time offender.
Yes, Your Honor. The people have looked at this case and the totality of the circumstances. There are serious, numerous, aggravating factors, including the fact that it was premeditated and planned.
Can an adolescent, a 17-year-old, premeditate anything unless it's the most serious thing? Can they?
Your Honor, the people
I'm
contend...
not being facetious.
I understand, Your Honor. The people contend that, yes, a 17-year-old can plan something. He planned this entire crime spree. He's taken advanced classes at his school.
Was it a crime spree that he was seeking or the followers? I mean, are we really here to deal with the accountability of social media?
Your Honor, the record shows that the adolescent offender's purpose and intent was to scare the community. He intended to scare them by driving against traffic.
Was that his purpose and intent? Wasn't it really to gain followers by having these videos, to whatever degree, played, and he would attract followers with that? Isn't that his motivation, as misplaced as it is?
Your Honor, his crimes are his conduct, not his motive. So what he did was he intended to terrorize the community. He drove on sidewalks.
You say he acted in a manner of terrorism?
He acted in a manner to fear, to create fear in the public, to scare people. It's in the record in pages 3 through 5 where he talked about it. He intended to scare the drivers when he drove against traffic. He intended to scare the elderly and the young.
Because he could film them and then get their shocked looks on tape and play them over for people. As misplaced as that is that the stuff of exceptionally heinous and violent conduct?
Your Honor, the people contend that, yes, it is cruel, especially cruel and heinous, hateful conduct to try to scare the entire community over the course of several days by driving vehicles against traffic, by swerving, driving recklessly on sidewalks, narrowly missing people. It is sheer luck that nobody was hurt in this instance. It is sheer luck that no one got hit by his car. It is sheer luck that when he threw eggs at people driving down the street, causing them to swerve, that he didn't cause multiple accidents. We can't have our public safety policy be because of sheer luck.
Counsel,
I'm sorry, go ahead.
Judge.
Go ahead.
Thank you. Counsel, if he's as bad as you say he is, why don't you just let it go to family court? He'll be back as an adult.
Your Honor, the people are not willing to risk the public safety and have him out on the streets to do this again.
Do you agree, okay, and I figured you'd say that, but do you agree that his actions that he was charged with reached the level of heinous under the standard?
Yes, Your Honor. Not only were there nonviolent charges, there was one violent felony charge from placing a false bomb in a public place in a public library under Section 70.02.
Heinous involves evil. Is that your position, that that was evil and that was his intent to do evil?
The people's position is that it is hateful to target the elderly, to target young children, to intend to scare a community.
It was not a real bomb, you know, right? It was a fake bomb.
Your Honor, it is still a violent felony charge.
I understand.
The statute 722.23.
Let's talk about the statute. What do you say in regards to Ms. Donahue's point earlier regarding its intention for rehabilitation versus incarceration?
Indeed, Your Honor. The people support the Raise the Age legislation. It was done in
Well, with
April.
all due respect, it's not up to the people anymore.
Understood.
The DAs, whatever
Yeah.
claim they made at the time, we're done with that. This legislation's been in effect since 2017. And so while there's so few cases nowadays, that debate is long over. The legislature tells us we want to raise the age of responsibility, and the legislature also tells us it's got to be a really unusual, unique case for a court to maintain it in an adult situation.
Indeed, Your Honor. And the people recognize that. This is that 1 in 1,000 case that my adversary mentioned earlier. This is extremely rare for an adolescent offender to premeditate, plan, execute, recruit. He was the architect and the ringleader of this crime spree that traumatized a community. And it's sheer luck that no one was physically hurt, but they were traumatized.
While we have, in this case, you are right, one violent crime, the placing of a false bomb in the second degree, most respectfully, if the people are looking for, quote, the case, wouldn't it be, as they say, more better to look for a case like in DB? That's a robbery one case. That's a serious case.
Yes, in DB, the People versus DB, which is an Erie County case, there was also serious physical injury. There was a robbery, multiple robberies. There was child endangerment. There was a 4.5-year-old child.
The gun in the victim's face.
The gun,
Awful.
Man that was beaten.
absolutely
And that's
terrible.
a good reason for passing the threshold of perhaps these words, highly unusual, heinous facts, defendant not amenable to rehabilitative efforts. Where do we have that in this record?
The people contend that it is heinous and hateful to target your community and with the intention to scare them and to execute these crimes that traumatize the community. The people also contend that these cases, they are rare. It's unusual. You don't hear about people placing false bombs. You don't hear about adolescent offenders doing social media antics that are to terrorize the elderly and the children in the community. Most of those adolescent offenders are trying to tell another teenager how to put your makeup on better. It's trying to do more positive things, not these negative things. And the people are not prepared to put the community at risk again if this adolescent offender, who, as Justice Glover noted earlier, is very interested in likes, he's very interested in this social plan. He has shown zero interest in rehabilitation. His school tried to help him. His school tried to get him to take responsibility for his actions. If you look at the record in pages 2 and 6, he doesn't do it. He won't do it. He thinks, he doesn't care, that he's cruel. His cruelty in his school actions was when he was dabbling in humiliation. Now he's taken to the public streets to dabble in fear. And the people cannot accept that we're going to put the public safety at risk.
What about the mitigating factors we heard about, i.e. the parents are now involved? We have a 4.0 GPA. What about those mitigating factors?
Justice Glover, I agreed with you when you spoke about the foreseeability of this, and a honor student, 4.0 GPA, doing advanced classes should have known that what he was doing by driving on the streets, on the sidewalks, and
I don't appreciate you turning that on me.
But so we contend that that's highly, highly inappropriate. This, the mitigating and aggravating circumstances. So the aggravating circumstances are, from the case law and from the discussions in the legislative record, was the adolescent offender the ringleader? Was the...
Let's answer that. No. He is the leader, but there's no one else following him, except following in the media. It's not like a gang, in other words.
Well, with respect, Your Honor, he recruited his friends to commit these crimes with him, as you'll see in the record, pages 3 to 5.
All right, so you want me to give you ringleader on that side?
Yes, sir.
All right, so let's go through them.
He also committed crimes over a series of several days. See the record, pages 3 to 5. He also acted especially cruelly and heinously per the People's Review, because cruel means to act without regard for anyone else's feelings.
It seems like you're creating the new threshold. Is that what you're doing?
Your Honor, every case, according to the legislative history, has to be reviewed on a case-by-case basis. So,
And let me be specific, for extraordinary circumstances, it seems as if that's what we're doing in this moment.
Your Honor, the extraordinary circumstances are from the legislative record. I'm just reading them. It was those 3 counts, plus in a case law, it talked about planning and premeditation being an additional aggravating factor. And then to add the biggest aggravating factor of all, this adolescent offender committed a violent felony. The mitigating circumstances from the legislative history speak to the adolescent offender's situation, his circumstances. Was he in substandard housing? Was he experiencing poverty? Did he have economic difficulties? Did he have learning difficulties? Was this adolescent offender kind of behind the 8 ball to start with?
So if he were, then we wouldn't punish him? But because this fellow was, quote, well off, we should.
Your Honor, the people would contend that this is, even if this adolescent offender was from a substandard housing or other economic difficulty, we would still be arguing for extraordinary circumstances based on the conduct.
You're arguing heinous. Couldn't you just as easily say reckless or mischievous?
Your Honor, the language is clear. It says this in the statute, especially cruel and heinous was discussed in the legislative history.
Your description and your arguments toward his acts. You say heinous, which involves evil. Couldn't you just as easily say reckless and mischievous?
Your Honor, the people don't find that targeting the most vulnerable people in the community and the community at large as being mischievous or reckless. We are seeing this as a serious public safety issue. The people need to maintain law and order, and we need to work to protect the public safety. And
you lack faith in the family court system that they can't offer the rehabilitation or the treatment or the counseling that he may need to assure that these things don't happen again, or at least to give it a try?
Your Honor, the people don't lack faith in the system. We lack faith in this adolescent offender. He has shown zero responsibility.
First time.
It is his first time in front of this court. It is not his first time being in trouble in front of his school, and his behavior just continues to move out.
First time, most respectfully, criminal offense. And as a first-time offender, do we simply say, you've used up your chances? The system is built on loads of chances. Even if he were to wind up in adult court, he still could be treated as a youthful offender, meaning have no criminal conviction at the end of the day. We don't know if he'd ever be adjudicated that way. But the bottom line here is the family court has the tools, does it not, to provide rehabilitation, but they also have the hammer. If he doesn't behave, this person can be incarcerated.
Yes, Your Honor. but the people are not willing to take the risk to the public and public safety. This adolescent offender conducted himself in a way with complete disregard for the safety of the community. He should have foreseen that serious injury could have.
Isn't that the point? He should have foreseen. We're talking about a juvenile, and we're talking about state of mind. Isn't that the point? He doesn't know yet. And now even his parents should have foreseen. They're the adults. But shouldn't we give a little bit more grace to our youth?
Your Honor, the people support nonviolent crimes being transferred to family court. There is nothing in the legislative history that says that first offenders get an automatic pass to the family court system. Extraordinary.
I've got to come back to my colleague's point, because the family court has a system in place, right? Wouldn't you agree, for the youthful offenders for purposes of rehabilitation? But there are lines even with that process, that if they fail to do certain things, then that matter may go to the criminal part. Shouldn't we give this young man that opportunity to walk through that door? Because he may not have foreseen what are the consequences of his actions, and give him an opportunity pursuant to what the legislator is desiring of a rehabilitative opportunity, rather than just thrust him into the criminal justice system.
Your Honor, my time is up. May I answer your question?
Yes, please, and then
Thank
conclude.
you. Your Honor, the people have no reason to believe, based on the record, that this adolescent offender is willing to change, that he's willing to take responsibility for his actions, that he is willing to take counseling and other services. We've seen absolutely nothing in the record. So with all due respect, thank you very much, Your Honor. We rest.
Thank you very much.
Thank you.
Rebuttal. Thank you, Ms. Donahue.
The violent felony in this case is still within the discretion of the court to transfer to family court, and nothing that will preclude the transfer. Additionally, the case law relied upon by Respondent to show that extraordinary circumstances exist are very distinguishable from this case, being that one of the cases, People v. DB, the adolescent offender was charged with robbery, which is a Class B felony, and in this case, we're dealing with a Class E violent felony. Additionally, the other case relied upon, People v. DJ, that adolescent offender was a repeat criminal offender who had fled from the police.
Charged with reckless driving.
Yes, Your Honors.
A very similar problem that we have here.
Yes, Your Honor, similar charge. However, that offender was a repeat criminal offender in the system. Additionally, the list of mitigating factors portrayed in People v. DJ is not exhaustive, merely illustrative. And the fact that TH has not had a bad life should not be held to his detriment. And in this case, the mitigating factors far outweigh the aggravating factors. Thank you, Your Honors.
Thank you so much. All right. So we will reserve decision and deliberate among us. Thank you very much.
All rise.
All right, everyone, please be seated. We've decided that in order to avoid unnecessary trauma on both attorneys' parts, we will tell you who is the winning attorney oralist first. However, winning is not everything, although somebody once said it's the only thing. We also want to provide a little bit of critique and background, because I'm going to share with you in a moment, and so will my colleagues, that both of you are at a professional level that you could argue tomorrow in the appellate courts. And as somebody who's argued hundreds of cases in both courts that are referenced here, I would be honored if I had you as an opponent or you were, quote, on my side. You're really both exceptional. This was a very, very hard decision. Frankly, we even inquired Could we have a tie? Well, the answer is no. Somebody has to win. And while both were truly exceptional, we believe that in the end, the effort went to the petitioner, Ms. Donahue. And so she is the winner.
What just happened?
All right. What? Okay. Very good. The law school does itself exceptionally proud every year when we do this. And there are many 1Ls in the audience today. I want you to think, today is September 16th of 2025. 1 year from now, this could be you. And it is easily done. Somebody once also said, if you will it, it is no dream. And so you can do this, and it just involves the work, and it shows so well. I'm going to ask my colleague, I don't know who wants to go first. Judge Bouse?
I could go first.
Okay.
Thank you, and it was impressive. It was impressive, and I kept putting myself back in your shoes, and that would have been between 1987 and 89, where I went to Toro. I'm a Toro alumnus. I think it's a different building, though. I'm not sure, but
The other one was
can't be
an
more proud.
elementary school.
That's right. And I can't be more proud of that. Neither of you had the deer in the headlight look, which, frankly, as a young trial attorney back in the very early 90s, I recall having, either looking at a judge or looking at a jury, and all that preparation, you forget for a moment. You didn't have that. You were prepared, and you allowed the rude interruption of these three jurists on a regular basis, but that's the way it's played. And for you to remain focused, keep your eyes on your arguments, and never sway, because if you sway, even though it may make sense to you, you're not there to sway. You're there to go and prove your point. And I have to hand it to you, Ms. Insalaco, that you stayed true to your point, and as the jurists all agreed, you had the tougher case, and it wasn't close. It was the tougher case to prove. Your position was tougher. When I was reading, I was surprised that the appellate division reversed, right, based on the facts that I saw. So you had a heavy ball to lift. So congratulations to you on that. But that wasn't our job. Our job was not to say, well, who won the issue? That was not our job. Our job was just to see who might have been slightly better than the other, and it was close. And if there was ever a tie, it could have clearly been a tie, but we didn't have that box to check. So you should both be very proud. I'm very proud of you, so thank you.
And Judge Glover.
The key is using the attentive ear. By using my words, you were listening to the argument and then used it for your argument. That's using the attentive ear. By pivoting, which is one of my favorites, I'm sure you were prepped that Dorian's going to say whether or not you pivoted or not. I enjoyed how when each judge asked a question, you were able to shift to the question and then return back to your point. I really enjoyed that because that's the biggest challenge. But each of you and those who are coming next and those who are going to be practitioners, whatever you do, it's about listening. It's about listening to your client. It's about listening to what the opposing counsel, what the witnesses are saying, and more importantly, what is the judge saying? And so we had an excellent demonstration on listening. So job well done.
I would only add that as a person who, after 50 years of practice, thinks of himself, I've done everything. You name it, I've done it. But I do think of myself as an appellate lawyer. Appellate advocacy is not the same as trial advocacy. I mentioned to both of you that privately. It is an art form known to just a few. And the art form involves much of what Judge Glover talked about. You got to listen to what the judges are saying and then work off that. But most important, you have to hold your own. For some in the audience, you might say, boy, these judges are nasty, they're rude, it's, as I always described it, sort of like in a circus, lion taming, if that's a good analogy. There you are, and all of a sudden the next lion comes off the podium and asks the question. You can't say to that judge or justice, back off, pal, I'll get to you when I feel like it. You've got to stop your train of thought, answer the judge, and get back. And so imagine how you'd feel. Our appellate division has 4 judges at once. The Court of Appeals has 7. The Supreme Court has 9. So imagine with all of these moving parts how you have to hold your own. And each of you did. Each of you did it with, in plain words, dignity and aplomb as true professionals. And so the school is greatly, greatly to be applauded for producing this kind of product at this stage of your legal education. And while this year's Bainbridge competition ends in a moment or two, the work goes on. We have trial competition teams, we have appellate advocacy competition teams, and we have courses which involve both. Take them. Avail yourself of them, because you can only teach this up to a certain point. After that, there's no way to do it except do it. And so, in the end, I congratulate both of you on really an excellent job, and I think that you're ready for practice now. Congratulations to both of you, and thank you very much.